Major Second Amendment news out of the United States Court of Appeals for the Fourth Circuit involving Maryland. A major decision, 2-1 decision by the Court of Appeals declaring that Maryland's specific rules associated with how you acquire handguns violate the Second Amendment, and Maryland essentially admitted as such. This is a big deal, folks, because there's a lot of precedents that have been set by this Fourth Circuit case, which we're going to talk about in 1 minute, and a huge win for several of our friends in the gun rights community. Stay tuned. Hey, folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, major decision in the Fourth Circuit. This is the U.S. Federal Court, the United States Court of Appeals for the Fourth Circuit out of Maryland, in a case entitled Maryland Shall Issue and Firearms Policy Coalition and Independence Institute versus a whole host of government officials in the state of Maryland, and there's some other plaintiffs as well, of course. Congratulations to all the plaintiffs in this case. Major win for the Second Amendment. Specifically, I will just read it from the opinion itself. This is a decision from Judge Richardson. He writes, quote, "If you live in Maryland and you want a handgun, you must follow a long and winding path to get one. Like with any firearms transfer, whether a purchase from a licensed dealer, gun show, or private person, or even a gift from a family member or friend, you must comply with Maryland's 77R registration process, which requires you to fill out an application with certain identifying information and then wait 7 days while the state performs a background check. And if you want to carry your handgun, you need a separate carry permit as well. But," as Judge Richardson in the Fourth Circuit continued onwards, "but for handguns specifically, before you do any of that, there's an additional preliminary step. You must also obtain a handgun qualification license, and getting that license requires, among other things, submitting fingerprints to undergo a background investigation and taking a 4-hour-long firearms safety training course in which you must fire at least one live round. Then, after submitting your application for this extra license, you must wait up to 30 days for approval before you can start the rest of the process. Plaintiffs seek to enjoin the state from enforcing only this additional preliminary handgun licensure requirement, and plaintiffs' challenge must succeed. It must succeed. The challenge law restricts the ability of law-abiding adult citizens to possess handguns, and the state has not presented any historical analog that justifies its restriction. Indeed, it seems that Maryland, has admitted that it could not find one. And thus, under the Supreme Court's new burden-shifting test, these claims that Maryland is asserting, Maryland's law thus fails, and we must enjoin its enforcement, so we reverse the district court's contrary conclusion. Big win for the Second Amendment over Maryland." And the concluding paragraph says specifically, this is from the Fourth Circuit again, quote, "In Maryland, if you are a law-abiding person who wants a handgun, you must wait up to 30 days for the state to give you its blessing. Until then, there is nothing you can do. The issue is out of your control. Maryland has not shown that this regime is consistent with our nation's historical tradition of firearm regulation. There might well be a tradition of prohibiting dangerous people from owning firearms, but under the Second Amendment, mechanism matters. And Maryland has not pointed to any historical laws that operate by presumptively depriving all citizens of firearms to keep them out of the dangerous hands. Plaintiff's challenge must succeed, and the lower court's decision to the contrary is not acceptable and fails." Okay, huge win here. Now, here's some of the key rationale. Here's the interesting thing, first of all. This is in the Fourth Circuit Court of Appeals. This is a terrible circuit for gun rights. Terrible circuit. So it is possible, if you're the state of Maryland, they're going to seek en banc review here and try to get the Fourth Circuit terrible court, pathetic court, when it comes to the Second Amendment, just pathetic, to try to grant en banc review and try to delay this. That is probably what Maryland's going to try to do. We will see what's going on here. Now, I will just digress just briefly, which is that, as you know, for those of you following Maryland law, which is a terrible gun state, of course, but it makes Baltimore a perfectly safe community, of course. I mean, there's no crime in Baltimore that I'm aware of. Thank God we have all those Maryland gun control laws, right? Well, anyway, We know that earlier this year, months before this decision was argued, as I recall, you had an argument about the Maryland assault weapon ban of Bianchi, and yet no decision has come out involving the Bianchi case. So one wonders what's going on there. I've got some speculation, and we'll talk about that in another video, but it does appear as if the assault weapon case involving Maryland and the Fourth Circuit there's some sort of games going on within that court, because it makes no sense for the assault weapon case, which of course is a semi-automatic firearm weapon ban case, to have been argued months before this case in Maryland shall issue, and yet no decision has been rendered in that case. And by the way, one of the judges in this panel here today was also on the Bianchi panel. So there's some games going on in the Fourth Circuit Court of Appeals involving the assault weapon ban, but we will get to that separately. But what is the other great news going on here with this Maryland shall issue victory? And congratulations again to the Independent Institute, to the Firearms Policy Coalition, of course, to Maryland shall issue, a great group out of Maryland. Congratulations to all the plaintiffs again. But again, with this said, the reason why I really like this opinion, in addition to the result, of course, is there's a lot of precedents that and statements that are made within this opinion that Second Amendment plaintiffs and Second Amendment judges who want to apply the Second Amendment correctly can use. For example, the argument by Maryland here was that because the right to keep and bear arms was not totally destroyed here because you just had to wait, that was not an infringement under the right of the people to keep and bear arms shall not be infringed. But here the court rejected that notion that only a total destruction of the right implicates the plain text, because as you remember, when the plain text is implicated, then the burden shifts to the government to come forth with historical analog. So if you are if you're a Second Amendment plaintiff, if you will, you want a lot of things to implicate the text of the Second Amendment because that shifts the burden to the government. And once the burden shifts to the government, as we see in this case, the government simply basically cannot win any major gun control laws or uphold them in modern day American life. And that's because there were very few gun control laws in 1791 when the Second Amendment was adopted, which makes a whole lot of sense if you think about it, because why would you adopt a fundamental right to keep and bear arms in the Bill of Rights itself, while at the same time pretending at the state and other parts of the country that this was not a right? Everyone thought this was right. That's why it was put in the Second Amendment. And of course, that's why there's very few gun control related laws at the time of the founding, because how would you pass laws involving or infringing upon a right? It makes no sense. The anti-gunners don't like that history, but that's the reality of it. So again, the good news is that the court looked at various dictionaries defining infringe, and they basically interpreted it as what I've said before on this channel, which is consistent with founding era understanding of infringe. Infringe means to destroy or to hinder. To destroy or to hinder. By delaying the process of 30 days, you are obviously hindering the ability of someone to get and keep and bear arms. And again, the court was very focused on this wait period that was imposed by the process. They basically said that law-abiding citizens who are not dangerous at all, law-abiding citizens who are not dangerous at all had to wait for the government approval up to 30 days in Maryland before they could acquire a handgun. And there's simply no historical analog supporting this. And this is very good news because in a lot of these states like New York and New Jersey, there are these long delays involving getting a handgun permit and a carry permit. And again, this is a powerful precedent, goes to the point that there is simply no basis for delay because it's inconvenient for government, and government wants to take that extra time to do their work because they're lazy or sloppy or inefficient or all of the above. So again, a powerful precedent that a delay is indeed an infringement because it hinders the right to keep and bear arms, especially if you don't already have a gun. It also bears mentioning there's a couple good points in this opinion. I'll put a link to it down below. Specifically, the court rejected analog laws that bar dangerous people from possessing firearms. And the reason is because the court said, hey, if you're found to be dangerous, well, maybe we can take your gun away, but the Maryland law is not focused on dangerous. They apply it to everybody, everyone in the state of Maryland. All American citizens in Maryland have to get pre-approval, and there's simply no historical analog for everyone in a state to have to get pre-approved to get a handgun. Maybe dangerous people could be restricted after they're found to be dangerous, after due process is given and so on. But for ordinary people that have not been found to be violently dangerous, those rules simply don't apply. Moreover, there's the state tried to rely on militia service laws about certain requirements associated with serving in the militia. But here, the Fourth Circuit made the right point that says, hey, militia training laws involve people that are in the militia, they don't apply to everyone in America that had a gun. So if you own guns and you were over the age of 45, or you own guns and you were a woman or whatever, the reality is those militia training laws didn't apply to everyone in the state or everyone in the country. They only applied to people that were in the militia and had obligations to the militia, and not to all gun owners in the country. And therefore, they said that's not a proper analog to use militia service laws or militia requirements as a basis for forcing everyone to go through this pre-handgun acquisition background check and process. And the last thing that's very important is we know that Section 3 of the Heller decision that talks about the Heller is not designed for, getting rid of long-standing rules about felons in possession and so on and so on. But as you know, that language is what I've said on this channel before, is dicta. It's not binding on anyone. It's just dicta. And yet the anti-gun lawyers and the anti-gun judges like to view that's the one aspect of Heller they view as inviolate law, that they can do anything they want. Of course, that's not true. They ignore the rest of the pro-Second Amendment discussions and focus on a few very specific exceptions. But the good news is this Fourth Circuit decision specifically rejected any reliance on the Bruin footnote dealing with shall issue licensing, and basically said that language and related language is really just dicta. It was not any official finding or ruling or holding by the Supreme Court. So therefore, they concluded they had to do their own analysis, which they did, and concluded there's simply no historical analogs to justify this Maryland law. So again, to close, the court said that forcing people to go through that 30-day long process and everything else is a hindrance to the right to keep and bear arms, because it delayed your ability to get a gun to be able to protect yourself, among other things. So that did constitute a hindrance that triggered the text of the Second Amendment. And once that occurred, the burden shifted to the government, and they said to the state of Maryland, all right, the burden's on you. Show us what you got. Maryland only came up with some analogs dealing with dangerous people in the militia, and the court says those are not analogs. They do not justify forcing everyone in the state of Maryland to go through this process, and therefore this process cannot satisfy the longstanding tradition of firearms regulation in this country, and thus it is declared unconstitutional under the Second Amendment and the Bruin standard, and of course the Heller standard as well. So, all right, folks, big news. I'll put a link to the opinion down below. Congratulations to the plaintiffs in this big win. We'll keep you informed as to what happens next. And again, don't forget to follow me on X at 4Boxes Diner. There's more Second Amendment information that I can cover on the channel on X, so check it out there. And again, don't forget to follow, like, and share this video. And again, we appreciate your subscription, and we look forward to talking to you more here at the 4Boxes Diner.
Orders up. Table 2A.